After several years of delays, the trial of Major Nidal Hasan started today at Fort Hood in Texas. It is Tuesday, August 6th. Welcome to Lunch Break. I'm Wendy Bounds. Hasan is accused of murder and attempted murder in a 2009 shooting incident at Fort Hood that left 13 dead and another 32 wounded. It is considered one of the worst acts of soldier-on-soldier violence in U.S. history. Major Hasan is representing himself in court, and joining us now to analyze this case is Professor Glen Sulmacy. He is Homeland and National Security Law Fellow at the Center for National Policy. Thank you so much for being with us, Professor. Let's start here. At the opening of this case today, Major Hasan, he apologizes at the opening of the court-martial. The facts of this case are really not in dispute in that he did conduct the shooting. So what really will be a question in this case? Is it what his sentencing will be?
I think in a military court-martial, it's an extremely fair process. But what really is fascinating is we're asking for the death penalty. This is a capital case, and there have only been 16 capital cases in the last 30 years in the U.S. military, and 11 of those have been overturned on appeal. So when they're going for the death penalty in this case, the military and the JAGs truly don't have a tremendous amount of experience, as you might otherwise expect in this arena. So when he's representing himself pro se, as we say, he's representing himself, he's fired his two previous attorneys. It becomes fascinating to watch to see if he makes any mistakes, if he does things to create a trial, a record of trial that will subsequently be overturned on appeal. So that's really what we're watching. But yes, it is a bifurcated process. One is the sentencing side, one is the trial side, adjudication, and the second phase will be this idea of sentencing, which really will either be life without parole or the death penalty.
In terms of him representing himself, let's go back to that for a moment. How unusual is that, Professor? And is there any scenario in which that could help his circumstances?
I think that's a great question, Wendy. It doesn't happen frequently in the military. We really try to be fair to allow them. And as you know, the government actually provides defense counsel free of charge, even to someone who is alleged to have committed the atrocities that the major has committed or is alleged to have committed. But what it really creates is an opportunity for him to make this a fiasco. He can, as you know, he has previously said that he is embarrassed and is asking for forgiveness from Allah for him actually serving in the armed forces and fighting against the Taliban. And his defense is a very awkward one, or he's raised, it's been said not permissible, but ruled not permissible, but he's saying that he was acting in self-defense of other Taliban fighters by doing this.
So let's talk about that for a moment. I mean, asking for forgiveness for Allah, saying that you were on, as he did this morning, the wrong side of America's war on Islam. How do those play out as a legal strategy? I mean, does it give him any heft there?
I think it makes it difficult in a jury, and it's a panel in a military court-martial. When it is an officer being tried, it is all officers that are senior to him in rank in the trial. So it'd be all senior officers to him. And I think it makes it hard to be fair when you're sitting there and he's killed civilian contract employees, civilians, and other members of the armed forces and injured them. And this has been going on for 4 years. He'll get the opportunity to cross-examine witnesses. So I think that's going to be very fascinating to watch. What it does, I think, is open up the opportunity for myriad possibilities for appeal. For him to have a successful appeal. It's very, very difficult, and I applaud the colonel who's the presiding judge over these proceedings to try to maintain order and not allow him to use this as a platform to espouse jihad or espouse the tenets of the Taliban and of Al-Qaeda.
And in terms of the witnesses there, I mean, some of these, of course, are people that were shot during this incident. How difficult? I mean, many of them, they're soldiers. They're trained to sort of contain themselves and to have control. But how difficult do you think is it going to be for them to be in that courtroom?
I think you have to think of the families as well that are involved here, that are sitting in the courtroom. It will be difficult. I think they will be constrained, they will be restrained, and will ensure that they conduct themselves in a manner you would expect of our armed forces. But certainly very, very difficult to have him cross-examining people on the stand who are involved in who are actually victims of the shooting. Quite difficult, and will be tremendously hard for the families. I think throughout this, we have to really feel for the victims and their families throughout this court-martial proceeding. I applaud the military, again, for what we're doing and how we do these sorts of items. We really seek to achieve justice. And you'd be amazed at how fair the proceedings are. But I really fear that he will use this as a grandstanding for him to espouse the tenets of jihad and against the tenets of the U.S. policy.
All right, Professor Sulmacy, thank you for your analysis. We will continue to follow this story and these proceedings on WSJ.com and in the paper. Thank you again.